I pulled up the wrong video. Hold on 1 second, people. Nerds. Okay, let's remove it. Let's do this properly. You're getting an extra head start today, people. Okay. Stop share. Share screen. Let's do this properly. Forget what just happened. Start again. Whatever. Let's just
sends you.
listen to this.
I can go in and I can pull up the reports myself, but I've not been doing that because we don't.
Mr. Jones, the question answers who's doing it now when you do get them.
Well, I'm not allowed.
Does anybody send you?
Objection. He's trying to answer, Judge.
I'm not allowed under the judge's order to tell you about what happened to my company.
That's not true, Mr. Jones. What I'm asking you is who sends you daily sales reports?
Yeah, he's answered, asked and answered several
I
times.
didn't get the answer, so can you say it again, or who would?
Okay, you're telling me to answer the question.
All right, so, well, I'm going to excuse the jury again. You're gonna get your exercise today for those of you who wear Fitbits. So just put your pads down and you'll follow along.
We're going to talk about this more when Barnes gets here, but we'll watch the video now as the
I
intro.
think he's following the rules here. I think he was probably gonna say one of the bankruptcy.
Who's that?
That's just the bankruptcy people are in control of it.
Who sends you the daily sales reports?
Objection, objection, objection.
All right, so,
They've taken it
So-
all.
Objection.
well, that was nice and
I'll
loud.
get there, Judge.
So,
That calls for the identity of the person.
no, so in fairness to Mr. Jones, he could have said whatever the lingo is for a bankruptcy.
A trustee is the lingo. A
Yes,
trustee
until
appointed.
yesterday, the CRO, the bankruptcy's in full control of everything.
So,
And they,
That's not responsive to my question.
Objection.
no,
because I can't say,
so the question, no, you did the right thing. You asked,
This is a trial, people.
sent him the daily, who gets the daily sales reports now, and if the answer was the bankruptcy person, then he knows he's not supposed to say that.
I said who sends you.
If it's the
Daily
bankruptcy
sales reports.
He
person,
says no one does. When he gets them, he gets them from the bankruptcy people.
I don't think he said no.
He
but-
said no
That is
one two or
correct.
3
All right,
times.
so
we're going to come back to this because this trial on the damages, because it's already a default verdict on the merits. It's a gong show. Well, someone says a clown show is probably more the accurate term. It's a gong show because what you have is someone, a party being restricted in what they can say, cannot, being told what they can't say, basically, and effectively told what they must say. A lawyer who knows the rules deliberately either pushing the envelope, trying to get Alex Jones to slip up, and we'll talk about it. That's what's going on in this trial. Alex Jones is being asked questions that he knows under the rules of this, what Barnes is going to call a kangaroo court trial. I don't think anybody can much disagree with that. He knows he can't answer it in front of the jury without being held in contempt, because this judge said she would be very, very ready to hold Alex Jones in contempt of court. A lawyer asking questions he knows Jones can't answer. Jones saying, I can't answer these questions. And then they have to kick the jury out while they have this debate over objections. We'll talk about it. But before then, people, how's everyone doing? It feels like it's been like weeks since we've last seen each other. It's been 48 hours. Thursday night, Thursday afternoon, I did a stream with Keith Wilson, the attorney for the Honorable Brian Peckford, among other people. We did a live stream talking about the most recent hearing in federal court in Canada about Brian Peckford's charter challenge. I was in New York City for the Rumble post going public after party. I was invited down, and I don't like traveling. Don't like traveling without the family. And I flew down Thursday, had the party Thursday night, flew back Friday. Let me just bring up one. I was going to start with this video, but I figured we had to get this video of Alex Jones out of the way so that everybody understands what is going on when Barnes and I talk about it. New York City, it's a unique place. This was from the terrace of the NASDAQ building, where Rumble is now trading publicly under the ticker symbol RUM. Spoiler alert, they had rum at the party.
All right, everyone on locals.
That's too loud. That's too loud. This was a locals exclusive post at the time.
Just a quick update. Robert couldn't make it down to the party, so I'm partying for both of us. This is the Rumble party right here. It's gone public on NASDAQ, and they're making party time. This is the building behind.
Look at New York.
Beautiful, beautiful.
New York is a beautiful city. Architecturally, the people are beautiful as well. There's a New York spirit. There's a New York attitude, for good and for bad. I got off the airplane, went to the bathroom, and someone cut in line. And the guy behind me is like, "Hey, yo, you can't cut in line." I was like, "Dude, we don't need to fight over a urinal." But it's beautiful. It's a beautiful place. Rumble has gone public. I noticed people saying they sold out already. That's the wrong take, people. Rumble having gone public now, merged with a company that was already trading publicly after getting shareholder approval. It's the new era now. It's the new era where you actually have, I know people don't like the interface. They have complaints, criticisms, constructive criticisms. It's going to be an alternative, a viable, ever-growing alternative for free speech in the meaningful sense, not free speech you can run around hurling ethnic slurs and insults, in the meaningful sense. And, as we've discussed in previous streams, employing terminology that is, Robert and I drafted it accordingly as relates to their terms of service, which is very much similar to what we saw in the legislation in Texas, prohibiting big tech platforms, once they've acquired a monopoly status of sorts, from imposing viewpoint discrimination. That is what we mean at this point in time by protected speech, free speech. It is public discourse that is free from viewpoint discrimination. So that's what's going on. Now, let me read. Oh, sorry, I didn't even give the standard disclaimers. The link to Rumble is in the pinned comment. And I see that Carly Ellison, the troll of trolls, is in the house trying to incite people to make false reports of terms of service or community guidelines violations, which is itself contrary to the rules of YouTube. But I don't care. But she pointed out one thing, which I felt necessary to clarify. It's against the community guidelines to refer people to other websites, other platforms. No, it's not. What is against the terms of service or community guidelines on YouTube is to refer people to videos or content that is otherwise not permitted on YouTube, because that would be doing indirectly what YouTube does not allow you to do directly. So just so everybody knows, the person who's in here in the chat encouraging others to report disinformation, timestamps of disinformation in my live streams, confession through projection, who could have ever thunk, is promoting misinformation in this stream to try to get me in trouble. Oh, and also trying to direct people to her account for DMs. Whatever, just so everybody understands that. Now, standard disclaimers. Christopher Walsh, $5 super chat, says, these days, if you didn't experience a robbery, you didn't experience New York. So funny story, I'll tell you that. I don't know if I'm getting crankier, more cynical, more tired, more curmudgeon-y. I've always loved New York City. I've always loved Times Square. It had a novelty, which I think has worn off now. Either it's gotten worse or I've gotten softer. But the hustling in Times Square, it's one notch off of just robbery. I mean, I call it polite robbery now. The hustle, in order to succeed in Times Square, it's gone from selling albums to we're going to get money out of your pocket, and you'd better just make sure it stays peaceful. I don't like Times Square anymore. I don't know if I'm cranky, cynical, looking for problems. It feels a little different in spirit, but Central Park is the most beautiful place out there. It's singularly unique. If New York City ever lost Central Park, the city would be done for. North Korea might be safer from your fellow citizens, but not from your government. Oh, so what else? Standard disclaimers. No medical advice, no legal advice, no election fortification advice. YouTube super chats, they take 30% over on Rumble, which I should have checked to see if we're live there. We have these things called Rumble rants, and I see two of them. A $50 Rumble rant from Medic Deb says, always grateful for your work. Thank you very much. And Grandpa's Place says, I went to move my channel to Rumble a week ago, and it still says pending. I don't know about that. So what do we have on the menu for tonight, people? Yeah, we got Alex Jones. We got the Alex Jones trial. I watched the cross-examination of Alex Jones. It's a masterclass in what not to do as an attorney, even if you hate the opposing party, even if you have nothing but disdain for the opposing party, even if you think they are the evilest scum of the earth, and even if they are the evilest scum of the earth, one does not comport oneself the way the plaintiff's attorneys is comporting himself. You don't do it. It's unprofessional, it's undignified, and it makes a mockery of the process. We're going to talk about Project Veritas. Pro tip: 3-card Monty is a scam. Etienne Degal. No, until Barnes gets here, let me share an anecdote. So I'm walking back from the NASDAQ to the hotel where we were put up, or we were staying. A guy comes up to me and gives me an album. He says, this is my new album. First, and then I say, no, thanks. He says, no, come on, it's good. He said something that I said, okay, I admire the hustle of the individual. I'll buy an album. It's probably going to be just as good as the last one I bought a few years ago. Good. I listened to it once or twice, as my grandmother said, the first and the last time. So I give the guy $10 and I take the CD. And then he says, no, I know you got change for that 50 in your pocket. I was like, what? It's like, you got change for the 50 here. And he starts pulling out money from his pocket. And I know that I don't have a 50 in my pocket. I know that because I didn't have a 50 in my pocket. I was like, no, dude, I don't have a 50 in my pocket. It's like, oh, I know you got one. It's like, you just take the CD back and leave me alone. And I didn't say it rudely, but that's how it ended. Basically, I just got mugged for $10. DeSantis and Trump 2024 Dream Team. Yeah, well, DeSantis is on the menu tonight as well, because DeSantis and other players are being sued for the Martha's Vineyard political stunt. They found a law firm to represent, the legal term is illegal aliens. I know that now. To represent some of the illegal aliens, to file a lawsuit against DeSantis for fraud, intentional infliction of emotional distress for having flown them to Martha's Vineyard, sued by a Soros group. Yeah, I was going to look into the the law firm representing them. Aaron Taylor, do I know the difference between direct and cross-examination? Yes, I do. Is that to say that a lawyer who has disdain for his opposing party should be disrespectful, should talk over them, should be absolutely emotional and out of control? No. Direct examination is, it depends on the context. Direct and cross-examination typically is when it's an adverse witness, which is what, oddly enough, the other party's witness, which is oddly enough what Pattis would have to deal with in terms of Alex Jones by cross-examining him, even though it's his client, after the chief examination by plaintiff's attorneys. Oh, Alex Jones was never cross-examined. So I made a mistake if I said cross-examined, Aaron. So point well taken. I'll correct myself. He was not cross-examined because Pattis we'll get into it, specifically said he's waiving his right to cross-examine Jones after the examination in chief from Attorney Maddie, because they'd be more limited in cross-examination, especially based on the rules, than they would be when they call Alex Jones as their witness. So yeah, sorry. If I said cross-examined by Maddie, I apologize. It was examination in chief. Oh, first Sweden, now Italy flipped to the right. Who next? Anyhow, so that's it. What else is on the menu? We're not going to start with something until Barnes gets here. Let me pull up. Let's start with something coming out of Canada. That's amazing. We'll talk about wordsmithing and why people hate lawyers. And I dare say sometimes rightfully so. My brother, who has now gotten very interested in the world around him, although he's been interested in it, he's gotten more vocal about it, less shy, has been noticing that on a lot of websites, or several websites in Canada, they're taking out, or they're discreetly editing out the term safe and effective when referring to a certain Fauci juice jabby. They're just discreetly started updating websites and removing the term safe and effective in respect of the jab for children. And I'll pull that up to show the homework. That's a frog that I saw in my. Here we go. The befores and afters showing safe and effective being removed. Now, these are from parenthomework.ca. They're not from government websites per se. I'm not actually certain who owns the domains, but this one was from kidshealthfirst.ca. Just discreetly, just memory holding it. We're living in George Orwell's 1984, where with the internet, it's so easy to change it because oftentimes, unless you've been paying attention the entire time, you don't even know that it's been changed. And is the internet slowly scrubbing references to safe and effective regarding the jab for kids? The sites were created by Ontario hospital coalitions that track ongoing safety and efficacy data. Is the new data driving the change? Did federal marketing funding dry up? Something else. Questions. Inquiring minds used to want to know. Now inquiring minds just want to shut up and sit down. But what I found just surfing one of those websites is even more amazing. Lawyer talk and legalese, non sequiturs. You're not being lied to, but you're being misled. Very interesting things. Check this out. This is from the kidshealthfirst.ca. Is the COVID-19 vaccine, I believe now, given what certain doctors said, this should maybe say therapeutic, but let's not, that's not the fight for this argument. Is it safe for children and youth? Oh, the answer they give is yes. Health Canada has authorized the Pfizer-BioNTech vaccine. So appreciate what you just saw there. This is called a non sequitur. It's silent. It's subtle, but it's a non sequitur. Is it safe? Yes. And here's a fact that indirectly could, imply safety, but doesn't in and of itself directly state it. Is it safe? Yes. And here's a random fact. Health Canada has authorized the BioNTech vaccine. They've authorized it. Is it safe? Well, the segue here that they're not making is they could not have authorized it if it were not safe. That's what is basically being said here. But notice they're not saying that. They're just saying, yes, it's authorized. Conclusion, quasi-unrelated fact. Children 5 to 11 get the pediatric vaccine, another fact, and children 12 and up get the standard vaccine. Just facts. The vaccine is given to facts. As part of the rigorous scientific review process, they have determined that this vaccine, here you go. Now they're going to get to the conclusion, how do they get to this conclusion? Safe with no serious side effects, works well in providing a strong immune response, and the vaccine is of high quality. Well, that sounds like it was actually translated from a foreign language. Listen to this, legalese. So these are the conclusions now. First the non sequitur. Yes, it's safe, and Health Canada approved it. Here they say it's safe, no serious side effects. What's to back that up? No serious side effects have been identified in the trials of 5 to 11-year-olds. Not no serious no side effects have been identified in 5 to 11-year-olds. No serious side effects, so that implies that some side effects have been noticed but not serious. Okay, set that aside. Have been identified in the trials of 5 to 11-year-olds. And then another fact, millions of people aged 12 to 17 have received the COVID vaccine in Canada. I'm not reading too much into it. I'm reading it the way it was deliberately drafted. No serious side effects have been identified in the trials of 5 to 11-year-olds. Well, this has been going on long enough now in real time that if I want to be reassured it's safe, I want to know that no serious side effects have been identified in 5 to 11-year-olds, not with that little bracket of in the trials, especially since I don't know how many 5 to 11-year-olds were in the trials to begin with. 200, 300? Wordsmithing, they're not lying to you, but they're misleading you in real time and egregiously so. There was one more super chat, which I'm going to see. How can the appeals court completely dismiss the Clinton sock drawer argument? I don't know what that means. Hold on, let me bring this up. I see Barnes in the backdrop now, and there's in our locals chat. People had some good recommendations as to what the top stories of interest were tonight. How can the appeals court completely dismiss the Clinton sock drawer argument? Okay, I'm going to flag that because I'm not sure what it means. People. Barnes is in the house. Remember, we're going to be going exclusive to Rumble at about the 30-minute marker. It's in the pinned comment. And by the way, if anybody does notice I say anything factually incorrect, tell me. Let me know. Don't impute malicious intent if I said cross-examination and not examination as though I did it on purpose. But let me know, and I will happily, gladly, and readily correct myself in the next live stream, which will be tomorrow. Okay, bring it in the Barnes. 1, 2. Robert, sir, how are you doing?
Good.
Let me see if your audio is loud. I'll let the chat tell us. Robert, before we get going, before you give us the menu of the night, I've gone over it. What book do you have behind you, and what cigar do you have in your hand?
The book is the book that we are reviewing at vivabarneslaw.locals.com, doing Friday night book reviews on different sections of the book throughout the month, this election season. It's The Emerging Republican Majority, written by Kevin Phillips. It was actually a text he started drafting in 1966. And he predicted things that became extraordinarily prescient in time. And cigar, just called HR. I forget which brand it is. But yeah, we got a nice, at least a dozen topics tonight to cover, including the Clinton sock drawer issue. That's in reference to the fact that Clinton put materials that were presidential records and potentially classified conversations, tapes of it, in a sock drawer and never turned it over to the National Archives. Judicial Watch sued, and that's the case where the federal district court said the president gets to make unilateral decisions about what is and isn't a presidential versus personal record in terms of the classification of it, and said that there was no right or entitlement by anybody to that other than the president. And but we'll get to how it applies. So we got a big electoral clause case up before the U.S. Supreme Court. We got whether Zuckerberg committed tax fraud as well as election fraud in his election fortification efforts. While we're still on YouTube for a few more minutes, we'll talk more bluntly about it when we're back over on Rumble fully.
Robert, by the way, they're letting people talk about this now on YouTube. YouTube is slowly, I think it's now becoming as acceptable as it became to talk about the Rona originating in a lab in China. But we'll see. Maybe YouTube is starting to feel the pressure of the Rumble.
We'll be discussing the Amos Miller, the Amish farmer case, and its consequences for everybody because it goes way past him or the Amish community. The Trump Special Master 11th Circuit decision that put the deep state over democracy. The Trump versus New York, the ludicrous application of a New York state law to try to take over all of Trump's businesses and bar him from ever doing business in New York again and take over all of his properties. Mike Lindell's suit against the FBI, being brought by Alan Dershowitz. The FBI caught lying in the lockbox case that we discussed previously in L.A. The continuing disgraceful show trial that is the Alex Jones trial. A comparable, another more piece of evidence, to the degree anyone needed it, that the D.C. jury pool is a waste of time as Project Veritas was assigned damages on a bogus grounds in a jury trial just held there. The, in my view, frivolous suit brought against Governor Desantis in Massachusetts, but it's in Massachusetts, so who knows, based on the Martha's Vineyard issue, where apparently getting free tickets, free hotel, and free food has become false imprisonment and intentional infliction of emotional distress. That's what happens when you let cases like the Alex Jones case go forward, as you're going to get bad, crazy legal doctrines. A pro-lifer who was raided by the FBI SWAT team style in front of his kids because they didn't like how he handled himself at a protest. The vaccine mandates, Head Start mandate struck down. Vaccine mandates in New York struck down. Vaccine mandate issues were being brought up in Canada to different responses. COVID insurance disputes about what is and isn't physical. And the Russian mobilization and referendums taking place in the Donbass and other regions of Ukraine. So whether to join Russia and whether or not the Balkans provide precedent from an international legal perspective for the legality of the actions being taken.
So, Robert, I mean, I don't even know which one should we start on. Should we start on the SCOTUS case, the
electors clause?
Electors
yeah,
clause?
that was add that to the poll takers at vivabarneslaw.locals.com. It and Amos Miller were vying for first. So yeah, we'll start with the electors clause case, and this is a case that if you were at vivabarneslaw.locals.com, you're probably familiar with the legal principles involved during the Barnes Law School videos we were doing back at the time of the election controversy and dispute. Back in November and December and January of 2020 and 2021. So the Constitution provides, under the Electors Clause, that the legislatures of each state will decide how people are represented in terms of federal office. This includes the legislature of the state having exclusive power over how they will pick the president, and the state legislature having power along with Congress over how members of the House and the Senate are selected. The issue has come up before the U.S. Supreme Court because many justices in the past have voiced concerns about what's been happening at the state level, which is state courts are intervening in trying to usurp the power of the state legislature. In particular, in North Carolina, once the state legislature became Republican and the state Supreme Court had a 4-3 Democratic edge, they suddenly decided that their free elections clause of their state constitution gave them, the court, the power to pick how redistricting would take place rather than the state legislature. They repeatedly rewrote the rules according to whatever standards they set, to such a degree that you had 4 political scientists appointed by a court who were affiliated with the Democratic Party and often met in secret with them, actually shaping and writing the districts that people will be elected from in 2022. One of the people they took out through their redistricting was Madison Cawthorn, who lost a large part of his district and then lost in the primaries. So the goal, this case up for the U.S. Supreme Court on whether that is patently illegal, that stripping courts of that power is the goal of the challenge. The Supreme Court has agreed to take the case. Briefing has already occurred. Oral argument is going to occur. And it's a major case that would restore the state legislatures as the source of power, not just in congressional elections, because the implication will be that they have the exclusive power in presidential elections, which will in turn potentially preclude what took place in 2020 from reoccurring again.
Break it down for the I just forgot the word now. The districting, when they what's the word? I just lost it.
Redistricting.
When they redistrict, I know we've talked about it. I'm not totally comfortable with the concept. How does it work? How often do they do it? And what are the criteria for redrawing the bounds of any particular districts?
So the way the Constitution provides is that the legislature of each state, once they're apportioned by the census effectively, which that's a separate dispute that's burgeoning up in the courts because the census somehow accidentally wrongfully determined the population of a bunch of states that just accidentally discriminated against conservative states and favored Democratic states, right? So we'll see if that ever ends up getting wrapped up. When Trump tried to fix the census, they took, Congress went nuts. They sued him. They took all kinds of things because they knew they had control over who was implementing and administering the census. And once again, they used the COVID pandemic because the census was taken in 2020 as the pretext for their errors. But putting that aside, census says, you state Tennessee, here's how many congressional districts you get. Here's how many representatives in the House you get. You always get 2 senators by definition under the Constitution. The senators are elected statewide, so there's no redistricting to be done. But in the case of the House of Representatives, there is. And so the question is, what areas within a state will determine who represents the state and the interests of the state in Congress? So, like in Tennessee, it's usually 9 members of Congress. So the Constitution next says exclusively vest the legislature of each state with that power. Now, sometimes the controversy has been, what if the state legislature itself, or by constitutional referendum, gives that power, delegates that power to an independent commission? A split 5-4 U.S. Supreme Court decision says that's okay. That's still legislative power within the meaning of the Constitution. But the 4 dissenting justices thought no. They thought that it always had to be done by the legislature of each state.
Isn't there a principle, delegatis non potest delegare? Would that be a case where the 5 say, by legislative methods, they said they can delegate this to an administrative body or somebody else, where the 4 says no, that it's their power, not theirs to delegate?
Exactly. Because it's a unique situation where the state legislature is explicitly, effectively kind of created by the U.S. Constitution. Because the U.S. Constitution says the legislative body of each state will be the state that determines the apportionment of how the districting takes place. The redistricting takes place. And typically it takes place every 2 years after a census, but sometimes there's redistricting that occurs in between there too. But typically that's how it works. And so it's almost a federal constitutionally created body. So the various lawfare folks on the left, once Democrats lost majority control of the state legislature in North Carolina, came up with a novel theory. Their theory is the definition of legislature under the U.S. Constitution is actually dependent upon the state constitution that creates that legislature. And thereby, the state constitution can limit the state legislature, and the state constitution can thereby give powers to either the executive branch or the judicial branch to overrule the state legislature. Many state constitutions include a clause that guarantees free elections. I would note the courts have never been willing to use that to enforce against fraudulent elections. Just a little side point. But the new lawfare theory was that the free elections clause effectively allows the judiciary to overrule the state legislature in redistricting, despite the explicit reference and exclusive power given to them by the U.S. Constitution. And they had always rejected that throughout history, pretty much every state. But once Democrats started losing legislative power in a bunch of these states, courts suddenly saw it totally differently, magically shifted their perspective. And in so doing, suddenly said, no, the electors clause, it doesn't define legislature. Legislature is what our state constitution says. Therefore, our state constitution can restrict our state legislature. Therefore, we can overturn redistricting. And they then also created a new constitutional right no one had ever heard of before, which was that free elections meant no partisan bias in redistricting. That's not at all what, of course, it means, but nor has it historically been applied. Again, Democrats are the masters of redistricting and have been for many, many generations. They're only discovering these when they no longer control the redistricting process. So the North Carolina Supreme Court overturned the state legislature's maps. They came up with all these little standards that just conveniently meant Democrats had better chances of winning House races. So the state legislature went back, came up with a new set of maps. Courts overturned that one. Said, nope, still not good enough. Not getting enough Democrats in there. They appointed 4 political scientists, disproportionately Democrats themselves, of course. There was motions to disqualify them that were ignored by the courts. There were communications between the so-called independent neutral experts and the ex parte communications with the plaintiffs, i.e. Democrats. And they came up with and they wrote the map in secret. So we went from the elected branch in public drafting the maps to 4 political scientists secretly writing the maps, which just accidentally, circumstantially ended up favoring Democrats. So they took the state legislators, and then a bunch of amici joined in this, took this case up to the U.S. Supreme Court, saying the North Carolina Supreme Court doesn't have this power. No North Carolina court has this power. Governor doesn't have this power because the U.S. Constitution exclusively gave it to us for a reason.
Well, let me ask, it's either the obvious question or the dumb question. Who then intervenes to not have oversight, but keep in check and balance the legislature themselves if they decide to do something totally funky?
It's non-reviewable. In fact, this was debated at the time of the founding. Should it be reviewed? The only people who can review the House and the Senate choices is Congress. that they have some supervisory role. But essentially, the founders decided we only want the elected legislators to be setting the rules for how electors get appointed and for how members of the House and the Senate get appointed. And Congress's only role will be as the Congress itself. They will have no role outside of what's separately identified over the state legislators' choice of electors. And the point was, if somebody else has that power, then you're giving that power to them. It's either in the hands of the elected representatives or it's not. The remedy, if they misuse their power, is at the ballot box. Now, the other two limitations are the 14th Amendment. One I agree with, one I don't. So the 14th Amendment clearly was intended to ensure that the manner in which redistricting was done would not be racially discriminatory and authorize the Voting Rights Act and other bills, though a lot of those laws end up being misused in my view. But clearly the Constitution did intend that with the 14th Amendment. Now, the other part that the U.S. Supreme Court just made up out of whole cloth is that the 14th Amendment requires one person, one vote. What this did is, like, people have asked, why can't we have a version of the Electoral College within a state if a state chooses to do so? Well, Tennessee long did. Tennessee gave more political weight to rural and small town areas to represent the culture and value of those communities than it did big cities. That meant that it wasn't pure one person, one vote in the apportionment of the state legislature. It was based also on where you happen to live, reflecting the political values of that community. U.S. Supreme Court came and said, no. One person, one vote, just coincidentally favored urban liberal Democrats, just put it that way, and urban political machines in the urban political establishment, and disfavored the rural small town communities that now could be openly politically discriminated against without protection. But those are the only two restrictions on apportionment. It has to be one person, one vote. It can't discriminate based on race.
Okay, and now, so hypothetically then, or not hypothetically, the courts can intervene if there's itself a constitutional violation in the manner in which the legislature is exercising its powers. Other than that, it's to the legislature, and if people don't like
the
it,
courts are only, if they're violating one person, one vote, or they're violating racial discrimination, the courts have power. Nowhere else. North Carolina is the one that said, oh yeah, actually we do. We can actually decide also whether it's partisan or not.
And so the Supreme Court agrees to take it up. What does that mean procedurally? When is there going to be any movement on this? Before 2024, but after 2022?
Probably after 2022 at this point, because they're operating with these maps. So but before 2024. I mean, the oral argument is coming up. The decision will issue sometime in 2023. So maybe sooner, but definitely by 2023. And my prediction, you've already had Kavanaugh, Roberts, Alito, Thomas, all voice, and Gorsuch, all voice the opinion that the Electors Clause denies and deprives anyone but the legislature of the state of decisions over redistricting, other than Congress. And so, there's your five. Barrett's an unknown, but my guess is I don't think Barrett would go AWOL on this one. So I think it'll be a 6-3 decision that determines that strips state will end the lawfare of state courts usurping this power. It will also end executive branch agency misconduct in the context of elections. And its biggest impact, in my view, won't just be redistricting. It will establish what I was arguing all the way back in 2020. The state legislature has the exclusive control over how electors are appointed. Congress has no role in that one beyond election contest, which is a separate issue. They have they don't get to oversee those rules at all. They do it over the House and the Senate. They don't over the electors. And by affirming that, it will explain just how illegal the 2020 election, unconstitutional the 2020 election always was.
All right.
Which we can talk about some of the who was up. Are we just on Rumble yet?
Well, I was going to say, I didn't realize we're almost 40 minutes in. People, I know some people don't like it. It's a little less convenient for the chat. We will live with it. Growing pains. And it's my agreement with Rumble anyhow. So it will grow.
I'm following the chat live at vivabarneslaw.locals.com. So if you want to hop in that chat rather than the Rumble chat, go ahead.
And I say, people, pressure on Rumble to fix the bugs is what they need almost. So we're winding it down on Rumble. Links in the pinned comment. And let's do this. 3, 2, 1.